upon the research that was been done, and it's been agreed to that. Put that aside. The next part is, which is, I think, lunacy, is the suggestion somehow we're not understanding. It's simple. And no one's suggesting, because you got such good people on the village, if in fact the area is owned by the church doesn't have to let anybody use it. You, me, the village, or anything. So the thing that you're gaining, which is something that's mystical here to chew on, the thing that you're gaining is you're getting a permanent lease, and all the poor folks are asking for is you keep it insured. But essentially, the terms are no different than anything else. If there's anything significant, Mr. Donovan and the people in our law firm will resolve it. There's no huge thing here, and this is truly, as Shakespeare would say, it's much ado about nothing. It's simple. You're going to keep on using it, and to suggest, which I think is really arrogant, why doesn't the church deed it to the village? Why doesn't the synagogues deed those things? Why doesn't the Catholic Church? You atheist? It's their property. It's no different than I can tell John Higgins, give me your house for some reason or whatever. It's their property. And suggest that they, for some reason, have to be motivated. They want to keep it. It's their property. They're Americans. They can decide what they do. All I want to do is let the village keep on using it. Use it for whatever reasons you folks want to do. You do a wonderful job, and no one needs to argue with it. But to make these suggestions, not provocative, it's saying things that have some level of, let's say, disingenuousness to it. And to suggest, as some gentleman said, why doesn't he give his house away? The village could use it. I mean, it's a ludicrous argument. It's simple. We want the village to have the property, God love you, for $1 a year. Just keep it insured because the insurance company required them to do it. If that wasn't the case, we probably wouldn't be here. This is not a difficult thing. It's truly making something so much more complicated than it is required to be. People want to make these public statements for whatever interest they have, then so be it. But this, to me, it's reaching a point of absurdity. No disagreement with people's right to speak, but goodness gracious, some of these things that are being said are so far afield for what's the reality of this. Use the property.
Greenwald, can I interrupt you?
I don't know the meeting.
The way we run it here is the speaker has the floor.
I'm done.
As time as he's finished, then we'll go to the next person. The lady over there want to speak?
Yeah, good evening, Hillary Surfer. I have a question about the liability aspect of this. Presumably there is not any overlapping of insurance. Who is responsible for the liability on that property, or does the church pay some of it? Does the church insure that property as well as the village?
According to this agreement, it says that the village will have to hold the church harmless. And the village will be paying the insurance, according to this agreement. So the church's liability coverage only applies to that area, the rest of the property that the village does not use?
No, what will happen, or let's go what has happened in the past, because there have been lawsuits, slip and falls around that area in the past, and what's happened is that everyone involved has been sued. Church, the village, the Rotary Club, because they provided insurance at one point in time. One of the things that was under discussion between the church and the village in this lease agreement is an indemnification and hold harmless. So if there was an injury on the property that the village would have to provide, we would have to list the church as an additional insurer, we would have to provide insurance, and we would have to provide defense. But that's typical in a landlord-tenant relationship. But again, that's an issue for the board to decide.
I have one other question.
Sure.
I always thought that that corner, the village green, was village property, and the church, just a very friendly relationship and loose boundaries and so on, and the, 4th of July, blah, blah. But given that that's church property, but we want to use it for public gathering, is there any possibility that the church would object to something that might be going on what is being used as public property, and thereby, in fact, is not? And will the church say, no, you can't have this, gathering here, you can't have this demonstration, you can't put these political signs up or what have you? How does that conflict or potential conflict get resolved?
Well, if I can just go back to the issue very briefly, the issue of title. Just so I became village attorney in 2003. This issue was presented at this time, and so I commissioned a title search on behalf of the village. Title company determined that the church had never issued a deed out to the village of Goshen since they took title prior to the American Revolution. So of record, there is no title in the village. There has never been a deed to the village. The title company that I use confirmed that. A separate title company that I believe the church used confirmed that, and I also did have the opportunity to speak to the director of Real Property Tax Service for the county, who also confirmed there was never a deed out to the village. In terms of the use and what's going to be allowed, the draft lease, and I have to tell you, it's been circulating around for in this format at least 3 years, but the language in here, and it's brief, so if you bear with me, let me read it to you. What it says under the heading use of the premises, it is understood and agreed that the village shall be the final arbiter and shall have the final determination as to what uses may or may not occur within Village Park, subject only to getting a permit from the village.
Okay.
Which is why it's troublesome when it goes back to, I'll find it. Go on, Steve.
Okay, Joe.
Perhaps I didn't express myself well before, and I would like to just clarify one question with regard to title. My understanding from previous meetings is that the church is looking for title clear out to the traffic light and out to the street. I don't know if it's center line, but they're claiming not just the grass area, but significant portions of what is the center hub of the village center. If that's not the case, we should hear it tonight. But that was my understanding, and I certainly have problems with the extent of that delineation.
Well, I know the church has asked for a quitclaim deed to certain properties. Until I know what the village board's position is on going forward, the village board and I have not discussed that at all. If you recall, it was brought up by Reverend Kingsley and his representatives at a work session a number of weeks ago. Also, if you have the most recent letter provided from Mr. Greenwald's office, it's in there as well. That is not an issue that I have discussed with you because it becomes germane if you decide to enter into the lease agreement, and it becomes not germane if you don't.
There was a survey map attached to this?
The survey was done. I don't have it in front of me, Joel. I want to say Dan O'Brien did a survey for the village on this area, on the arc, where the benches are. There's a walkway there. From behind the benches, in. Okay, I think the church at a subsequent point in time had Jim Dillon do a survey, only because it's a small town. If you stand there with a survey crew in the middle of the village, you prompt people like the village attorney to stop when he's driving by and ask him what the heck he's doing. But
well, they said in the meeting that Dillon had.
Right, but the village, we have it somewhere. But I want to say Dan O'Brien, who was a local surveyor, did a survey on behalf of the village, probably in 2004, 2005.
Well, just for clarification of everyone here, what are we talking about tonight? Are we talking about clear out to the traffic light, or are we talking about somewhere to the east of the monument?
Well, it would be on an arc behind the benches, forward.
When you say forward, you mean towards the church?
No.
Backwards.
Towards the street. From the round, all the parts that you've thought of in the past as the village street. From the sidewalk forward.
All the way out to the horse fountain. Stanley Goluboski's horse fountain.
That's what we brought up last time.
That was my understanding.
Yeah.
I would just like people to understand that and be clear about it. I mean, basically, you're
including the upper monument
about dedicated streets and state highway. And I'm not sure the village has the right to convey that property at this point.
I can tell you, I don't know the answer to that question.
And the other question that was brought up for you before, and I think it's a really interesting legal question. I
think every question is an interesting legal question.
Not going to resolve it tonight.
Could you ask Art these questions, Sean?
The question of the pre-revolutionary title. And there must be precedent on this, but it's pre-revolutionary title. There was a revolution. What's the standing of that title?
Well, I have to, everyone is talking here, and I think we are all allowed to say, and I hate to get,
And maybe the American Indians know it.
I think that the difficulty here is, when I was mayor, this issue.